chair this panel, and to my colleagues. Now, let me very immediately pass to Associate Professor Konstantinos Antonopoulos, who is a professor of international law at the law faculty at the Democritus University of Thrace, and also directors of the Krateros, how is it called? I need to open my papers. It is the Krateros Ioannou Researching
Institute of International Law and International Relations.
I'm really sorry, I have to open my notes. Professor Antonopoulos, thank you very much for chairing this session, and I give you the floor.
Thank you. I thank you very much for the invitation to chair this panel. And I would like to extend my warm greetings to Professor Koufa from directly the opposite side of the country than Athens. And this is the last but not least panel of this very stimulating conference. And its subject is EU responsibility when multiple actors are involved. This raises questions of engaging the responsibility of a plurality of actors, and these issues shall be addressed by two learned international lawyers that have researched and published extensively on this subject. I'm very pleased to welcome Dr. Ilias Plakokefalos and Dr. Vladyslav Lanovoy. Dr. Plakokefalos is a fellow at the Athens Public International Law Research Center and formerly an assistant professor at the University of Utrecht, and before that a postdoctoral researcher in the SEARCH project of the University of Amsterdam. In this capacity, he co-edited two of the volumes on shared responsibility that were part of the outcome of this project. He is going to present a paper on the guiding principles of shared responsibility, this very interesting concept of constructive ambiguity. And Dr. Vladyslav Lanovoy is Associate Legal Officer to Judge Benoun at the ICJ, and formerly lecturer at the Lille Catholic University. He has also worked at Freshfields, Brookhouse, the Ringer LLP, and the Permanent Court of Arbitration, and as consultant to both the UN Office of the High Commissioner for Human Rights and UNEP. He's the author of a monograph on complicity and its limits in the law of international responsibility that was awarded the prestigious Paul Guggenheim Prize in International Law in 2017. His paper is on a more specific concept, that of complicity, and in particular, the aid or the responsibility for aid or assistance in the commission of an internationally wrongful act, the EU and its member states. So I give the floor to Dr. Plakokefalos according to the list of speakers before me. And I kindly ask both speakers to keep to the time, as we are at the end of this conference, and I understand that everybody's pretty tired. So please, Dr. Plakokefalos, you have the floor.
We cannot hear you now.
Nope, we can't. Nope. Nope. Shall we go to Vladyslav and then return to Ilias, perhaps? I don't know.
Yes, we can start with Dr. Lanovoy, and while Ilias is trying to fix the problem. Okay. So, Dr. Lanovoy, you have the floor.
Well, I hope you can hear me.
Yes.
Okay, great. So I'll try to also quickly just make the share of the screen, which I hope you can see. Can you see it?
Yes, yes, we can see it. Yeah.
Great. Well, I guess we will revert the order. So rather than starting from the more general, going to more specific, we will do the other way around, which is of course not a problem. It is a real pleasure to be here with you, and I would really like to thank the organizers, and in particular Vasilis Paragantis, who already mentioned in earlier discussion that Vasilis used to be the most able and the intellectually most interesting assistant at the time when I was doing my master's studies at the Graduate Institute. And Vasilis worked with Professor Vera Gola and Debas, who is certainly a late professor whose work has made a real impact in this field as well, in that of responsibility of states and international organizations. So, I mean, of course, the advantage of being one of the last speakers is that you really feel that everybody's getting tired. So obviously, I hope that I won't end up getting to say any barbarities. But what I want to make sure here is to address a specific problematique, which I think we haven't yet touched in the discussion. And that is what happens when the EU and or its member states knowingly render aid or assistance to third parties, i.e. other international organizations or non-member states. Under which circumstances can such aid or assistance to an external partner give rise to legal consequences for the EU and its member states under international law? Now, of course, this problematique, which I would like to address to you in the next couple of minutes, could be expanded even further, and we could wonder to what extent such regime of responsibility could even be construed as a regime for allowing for a new mode of attribution of conduct in situations where there is a specific relationship between a member state or international organization rendering assistance, for example, to fairly well organized non-state actors operating outside and going on to commit certain violations of international law. But I will leave that completely aside. It's a fascinating discussion, but for a different day. So at the outset, also let me say that the specific question that I would like to address today to you falls precisely within this broader legal question that we have been discussing the entire day, which is how to allocate responsibility between an international organization and member states, which obviously raises a host of theoretical and practical issues and perspectives. Many of these have been very eloquently addressed in a recent study on the guiding principles on shared responsibility, of which Ilias was one of the main authors, and which I have had a chance to participate in a number of discussions. So from a theoretical perspective, I think many of the things that we've been talking about throughout the day really kind of boils down through which spectacles we are looking at the problem and how we're examining that relationship between the international organization and member states. So the answer, of course, would depend whether one looks from a purely treaty law perspective and thus see the sort of the idea of international organization as the creature of the will and consent of states, or if one looks from an institutional setting and tries to think about an organization such as in the EU as a legal order in and of its own right. Now, of course, this balancing exercise informs the entirety of the very logic of responsibility of international organizations, i.e. on the one side, the need to ensure that an international organization has effectively distinct legal personality and therefore could be a bearer of certain rights and obligations, and of course independently engage international responsibility, as well as the idea that there are situations where in fact member states may have to chip in if in the event, for example, where the certain organizations, or such, not necessarily the EU, but may have engaged certain debts, and financially member states may be better placed to provide redress to an injured party. Questions such as relevance of the internal rules of organization, to what extent this is internal law or part of international law. These are all a host of theoretical questions which are fascinating. At the same time, it raises a number of practical questions, and it suffices to look at these different little images for you to see how many potential cases of aid or assistance one could think of. And of course, we have to be extremely careful to the extent that most of these are allegations and they need to be corroborated, but we can imagine situations going like the Frontex and its activities on the external borders of the EU, questions of conclusion of association agreements or fisheries partnerships, and to what extent questions of aid or assistance could arise in that context, in particular with reference to the Polisario saga, questions of migrants controlled more generally, questions of intelligence sharing, questions of arms exports. These are different potential factual situations which could possibly give rise to situations of aid or assistance. Now, of course, to give you an indication of where we are, we have mentioned several times today that the practice itself is lacking, you know, that many of the articles of the ARIA were based on a very incipient practice. In essence, there was almost verbatim transposition of the relevant rules and principles from the Articles on State Responsibility to international organizations. But if we were to say that, then of course this means one of the two things. Either the EU and its member states never actually give any aid or assistance, which is used for the commission of internationally wrongful acts by external partners. And this would be a purely formalistic view of almost elevating the EU and its member states to the position, well, the king can do no harm under any circumstances. Or alternatively, and this is the argument that I want to run with you, and obviously time being short, I will have to conceptualize this, is that the conditions for this specific regime of responsibility that needs to be met for the responsibility to be engaged are so narrowly construed that in fact they leave the situation in a limbo or in a situation of real constructive ambiguity with very little effet utile for this regime of responsibility in practice. And I will try to demonstrate that in three parts. First, just very briefly recapping and situating the responsibility for aid or assistance in the general logic of international responsibility, and to what extent normatively it is a sound regime the way it has been conceptualized by the ILC. Second, I would like to examine very briefly the knowns and the unknowns of this regime of responsibility as is set out in the relevant provisions of the ARIA, which in essence are nothing else but the replica of the same vineyard, so to speak, when it comes to looking at Article 16 of the Articles on State Responsibility, just a different date of production, one in 2001, the other one in 2011. in so doing, I hope to convince you that perhaps the hasty analogy between states and international organizations may have led too quickly Judge Gaia, who was at the time special rapporteur of the area, to dismiss some of the serious objections to the specific constituent elements of this responsibility, as were raised both by states and international organizations throughout the codification process of the area. So context, and what you see on the screen is a wonderful quotation from Roberto Ago, who was a special rapporteur, one of the probably most brilliant special rapporteurs on the Articles of State Responsibility, who in 1939 said, "No such thing as complicity or aid or assistance could ever be envisaged in public international law and the relations between subjects in a purely horizontal system, but rather these are concepts coming essentially from a criminal law logic, and they would be with great difficulty transposable to states." And of course, he couldn't even think at the time of international organizations. And just in 1978, just a few decades later, the same Roberto Ago, of course, came with what I would call the big bang of complicity, suggesting that it's really the international legal order must recognize that no subject should knowingly aid or assist the other subject in the commission of an international wrong. So in essence, the various intricacies of the codification process led us to the concept of aid or assistance, as it figures now in Article 16 of the Articles on State Responsibility, and essentially the same provision has been taken over for the Articles on the Responsibility of International Organization, and you can see it on the screen, and it's blatantly evident that there are essentially two key components, at least as it transpires from the text. That is that the organization which is providing aid or assistance to another state or international organization must do so with the knowledge of the circumstances. And then the second requirement, which is the opposability requirement. So in essence, that organization providing aid or assistance, the principal conduct which is being committed would have been wrongful if it were committed by the organization itself. And in addition to that, we know that there are further limitations as they derive from the commentaries. That the relevant state organ, in this case, the organ of the international organization, must have intended to facilitate the occurrence of the wrongful act, and that actual wrongful conduct has been committed, and that the conduct of aid or assistance must have significantly contributed to the commission of the internationally wrongful act. And then, of course, there are the so-called unknowns, where the regime is still in some sort of development, precisely because the comments, I think, get it blatantly wrong. And there are contradictory references in those commentaries, as are shown on the screen. On the one hand, there is the idea that the aid or assistance itself does not need to be essential to the commission of the internationally wrongful act. At the same time, there is a recognition that there may be circumstances where aid or assistance would have contributed only to a minor degree, and yet it could still trigger legal consequences. So we see that there's this difficulty in conceptualizing. On the one hand, it's easy to say, well, it's derivative, because in order for you to be responsible for the act of giving aid or assistance, the principal wrongful act must have occurred. So you can see the derivation process. But at the same time, the Commission opens here loopholes as to how situation may then be different once we get to the subsequent stage in the state responsibility analysis, that is of the content. And when we look at how the injured party who will be trying to seek reparation, how they could potentially seek reparation from the principal wrongdoer, but also from the state or international organization which has provided aid or assistance to the commission of that wrong. Now, the EU was not just an innocent bystander in the elaboration of this provision. And in particular, the EU insisted that the provision should be, when it was being drafted, the Article 14 should actually clarify expressly that it is only in situations where the aid or assistance is intentionally being given for the commission of the internationally wrongful act that such responsibility would arise. So you can see here that EU was worried that some of its actions, such as, for example, development aid, would not then be somehow the policymakers would be wary of taking such decisions because of the fear of actually engaging responsibility. And of course, the EU was not alone. Many other financial institutions raised the point about the difficulty of even thinking about such responsibility being applicable to their actions. And World Bank and IMF and their fascinating comments are also on the screen, which show to you that in their view, once, for example, IMF gives its loans, it has no control whatsoever over the conduct of the alleged principal wrongdoers, so the state that might have received those loans, and the fungible character of some of the financial assistance it provides would basically get it off the hook as a matter of principle. So you can see here the type of considerations that the EU and other international organizations raised in respect to this form of responsibility. I know that the time probably is running, and what I would like to emphasize is essentially by replicating the same provision, the ILC ignored quite a number of comments which raise difficulties with some of these elements, namely the element of knowledge, but also some states during the elaboration of the ARIA even questioned whether the aid or assistance should only be situations of positive aid or assistance, or there could be omission could be part of the scope of the provision. Many states and international organizations argued that the requirement of opposability, the requirement that the conduct should be wrongful for both the aiding entity and the principal entity, also made very little, if not no sense at all, in the circumstances where there are two different subjects involved, such as international organization and states, as of course one would struggle to find the exact same obligation which would be binding both on the international organization and on the state. And so to what extent this requirement of opposability had very little relevance in this context. The other kind of iterations of the aid or assistance regime are found in the Article 42 to ARIA, which of course deals with a very peculiar situation where aid or assistance may be provided after a serious breach of a peremptory norm has occurred, and so that aid or assistance would allow maintaining the unlawful situation in place. And finally, Article 58, which essentially replicates the opposite scenario where a state would be aiding or assisting an international organization, yet taking up, as you can see, exact same criteria, except for introducing this famous safeguard clause in paragraph 2, that an act by a state member of an international organization, which is done in accordance with the rules of organization, does not as such engage the responsibility of that state. And this is, of course, has generated a flurry of debate as to whether, for example, voting procedures and the way in which states may be voting or not voting in the context of an international organization could engage their responsibility. or whether that is covered by the rules of organization, and so they will fall within this provision. So on that note, essentially what has happened to the entire regime on aid or assistance is that we ended up with something which, as Manley Hudson noted many years ago, sometimes it is less profitable to seek clarity than to arrive at acceptable ambiguity. And this acceptable ambiguity is in fact one of the reasons which probably can explain why there has been so little actual application, and how hard the threshold is for many of these factual cases and scenarios which I referred earlier to fulfill all these stringent conditions, and therefore for this form of responsibility to have any significant effet in the international legal order. That being said, it still has a serious added value in the sense that any policymaker, any decision maker, be that of a state or an international organization, is wary of the concern of whether a tranche of money, a particular military assistance, a particular sending of weapons which might be used, for example, in the commission of human rights or international humanitarian law violations, may trigger responsibility. And that's precisely where they're going to look. And their decision-making probably will, in most cases, proceed on the assumption that it is almost impossible, if ever, to actually be responsible on this basis. That is my perhaps slightly provocative point to you, but I think Ilias will elaborate further on a number of topics of common interest. Thank you so much.
Thank you very much, Dr. Lanovoy, for this thought-provoking and very clear presentation. I wonder whether these limitations on aid and assistance could be remedied by the concept of shared responsibility, which is flexible enough to serve as the means to address them. And I hope that Ilias has overcome the technical problem that...
Hello?
Yeah. Hello, yes. Yes, we can hear
That's
you,
good.
yes. And I give him the floor right away.
Thank you so much, Professor Antonopoulos. It's a pleasure to have you chairing this panel. Vasilis, thank you very much for the kind invitation, and also for the somewhat uncanny idea of pairing me up with Vladyslav, which I don't know with whom, I don't know how many of you know, actually. I know Vladyslav for many years, and we've crossed paths also in academic journals more often than we have planned to. So it's a real pleasure, and also to see everybody else around here. It's great. Now, after the technical difficulties and Vladislav's presentation, I feel that I should say something extremely important, like, something spectacular. I'm afraid that is not the case. I will just have to sort of, I don't know if rehash is a good word, but tell you the story of shared responsibility that manifested itself once again. I had one more reincarnation in the form of guiding principles to shared responsibility. Now, what are the principles of shared responsibility? That should be the first question. Now, the initial idea on shared responsibility back, I don't know, 10, 11 years ago was to address a very important problem in international law, international politics rather. That is a problem of many hands, as is the term that is used in international political theory and organizations theory. That when you have many actors that act concurrently or independently and at the same time, whatever the case may be, then it's very easy for them to evade responsibility because it's very difficult to put the blame on one of them. That is the simple, crude way to explain the problem. Now, why is this interesting in international law? Well, because it seems that it happens very often, and it will keep happening even more often in the future. That is, having states cooperating, states forming joint organs to manage specific situations. Think of the case of Nauru, think of the Coalition Provisional Authority, think of Eurotunnel, think of a number of instances where we've seen this. States and international organizations working together, international organizations working with non-members together. If we put the non-state actors into the picture, you understand that this is a whole matrix of situations where guidance would be welcome in international law. Now, why was there a problem to resolve? So you have a factual situation and you need to also have some sort of a legal problem to resolve. Well, the International Law Commission, in its articles on state responsibility and the articles on the responsibility of international organizations, both sets of articles being somewhat, you know, an Italian affair with Ago and Gaia, and before Ago, you know, basing a lot of his work on Ancelotti. There's a lot of, you know, incestuous Italian thing there, which is very nice actually, because we can trace ideas back in time. Like Vladyslav showed us, what was it? 1939 was it the Ligne Internationale? No, yeah. So we know where to look. And one of the things that the Italians didn't do well, one of the few things, if not the only thing that didn't do well, was to take this into account, take this problem into account. So we have one article in each set of articles dealing directly with the issue of multiple responsible states or international organizations, and you have hints of the same thing all over the place. You have a hint when it comes to Article 8 of the Articles of State Responsibility, when you have effective control. You understand that there's more than one party being involved in wrongful conduct there. Vladyslav explained to us why an assistance is one of these instances, but that was not a systemic sort of approach to deal with issues like that. Now, granted, it could have been so, right? These were enormous projects undertaken over many, many years. Not all problems could be resolved. Enter Shell's project that tried to address a few of these shortcomings, and not even shortcomings, maybe clarify a few things, explain a few things, bring a few ideas to the fore. It's not that our work, as far as I'm concerned, in Amsterdam was any kind of, you know, we didn't try to reinvent the wheel. We didn't try to do things that were extraordinary, but we thought that we did a really good job in putting things together and bringing and discussing the issues, right? Over a number of years with a number of colleagues and a number of judges and a number of, you know, legal advisors to governments. It was an extensive project that culminated into the guiding principles only in order to have everything together in a very handy document, if you will. Now, drafting the principles was extremely difficult, I can assure you. It took many years as well. There was a lot of back and forth. There was a lot of voting. There was a lot of people, you know, not reacting to provocations, friendly ones from very nice colleagues. And so we ended up with a compromise, as one would expect. What are the interesting parts of the guiding principles when it comes to the European Union paradigm? Now, I'm afraid that like most of them have been already covered by the speakers before, but I will try to sort of give a very short overview of what type of situations we try to deal with and how we try to deal with them. Now, first, of course, is the idea that the idea of shared responsibility itself has an application to the European Union and its member states, or the European Union when it's working with non-member states. That is, the Commission, the definition being the commission of by multiple international persons of one or more international wrongful acts that contribute to an indivisible injury that entails shared responsibility. Now, the key, besides the multiplicity of actors, which is sort of a given, is the concept of injury being brought to the fore, something that is not part of the definitions of responsibility in either sets of articles. Now, in our work, injury excludes legal injury, right? Because it wouldn't make any difference. Legal injury does not make any difference whether it is being committed by one or multiplicity of actors. And one key component is that the injury has to be indivisible. Now, how do we determine this? The only way we found that it can be determined is by applying a factual test of causation. Granted, a test that is strict in the sense that it excludes many situations as shared responsibility. It's a test of exclusion, right? A simple factual but-for test of causation. Yet that doesn't mean that these situations are not addressed under normal headings of responsibility, right? So it's not that because an injury is divisible and it does not fall under the rubric of shared responsibility, that is not addressed as a separate sort of heading of responsibility. Okay. Now that's one. The second principle that bears some sort of has some import when it comes to the European Union is the explanation of the first one is that international persons share responsibility for a single internationally wrongful act when the same conduct consisting of an action or omission is attributable to multiple international persons. There we have multiple attribution finally spelled out, on paper, and constitutes a breach of an international obligation for each of those international persons. Plus, of course, contributes to the indivisible injury of another person. Why multiple attribution is important? It's not that we hadn't heard of it. We knew of multiple attribution. We knew it existed. Everybody has seen it. Everybody has, thought of it. But it was not systematically, placed in the right context. So we felt that this is a contribution towards acknowledging that multiple attribution is a reality. We had decisions of international courts and regional courts avoiding the issue. We all know cases like the Krami. We had that problem where regional courts or even Bosphorus, right? That the problem that the court would not go down that road for many reasons, political or practical, doesn't matter. But multiple attribution is there. Now, moving on, I would say that Principle 7 is also important. Principle 7 talks about concerted action, and it says that an international person shares responsibility when it knowingly acts in concert with another international person that commits an international wrongful act, and the conduct of each of those international persons contributes to the indivisible injury of another person. Now, in the commentary, there's an example of the European Union Turkey statement as showing that you might have a perfectly legal vision rather, by making the joint statement, but in practice you have problems of violations of international law, or you may not. I don't know, as the case may be. I can assure you, though, and this is sort of I try to. I'm speaking now with the hat of my previous job, working for the government. That in the European Council, oftentimes proposals are being tabled, especially when it comes to refugee law, that are exactly that, fall under that heading, considered action to process asylum applications completely extraterritorially, meaning outside the borders of the European Union, working and cooperating with entities, states or non-state entities that are not, so to speak, not being loaded for the human rights record, and so on and so forth. So I'm trying to say that this is a reality, and this has to do a lot with the European Union, how it conducts its affairs with non-member states when it wants to push a problem out of its way. Moving on, Principle 8, which is the immediately following principle, says that an international person shares responsibility when it knowingly controls another international person in committing an internationally wrongful act. Right? Now, this is important, again, in the discussion of normative control that has been going on in the conference, in the sense that it's clear that now, in the case of the guiding principles, control includes normative control, because it says acts of international organizations. If you see, Principle 8, paragraph 2 says control for purposes of paragraph 1 includes situations of direction and control. Acts of international organizations and coercion. Acts of international organizations can be just the adoption of a regulation that is being implemented by the member states of the organization, and so on and so forth. I don't want to get into this, not because it's not important, but because I think it has been exhausted so far. I would like to add one more principle that I think is interesting. That's Principle 10 on joint and several liability. I understand that this can sound somewhat controversial in the sense that it is implied in Article 47 of on the Articles of Responsibility of States. It's not clearly endorsed. The primary idea behind this is to not leave the victim without access to restitution, compensation, reparation, generally speaking. But it is also important, as I will actually quote Dr. Vasilita, saying that the possibility of joint and several responsibility could be one of the reasons of EU's declaration of competences to international agreements. It is not only important, what I'm trying to say, when you claim a reparation, it is important as sort of as a reminder of states what could happen if someone claims reparation, so they have their affairs in order and everything is very clear beforehand, especially for the European Union when it enters an international agreement. Another reason why this article is important, a little bit, not so much concerning the European Union, but important nonetheless, is that recourse to international justice, as we know, is often fraught with many problems. Consent states, the diverse legal avenues, the monetary gold principle, you name it. So removing one obstacle when it was already implied in the principles, in the articles on state responsibility, seemed like a good idea, and again connected to the European Union, especially when it comes to its policy decision to declare competences in international agreements. I can go on and on and on the principles, on the guiding principles, but I think this would be a great time to stop. And thank you again, Vasilis, Professor Antonopoulos, very much, Vladyslav, for having this discussion. I'm open for any questions anyone has.
Well, thank you very much, Ilias, for this very interesting and thought-provoking presentation. I have one question on the Q&A from Mr. Nikolaos Giannopoulos for Dr. Lanovoy. And the question is whether the elusive phrasing of the rules on aid or assistance allows the potential for parallel responsibility of an international organization such as the EU for non-complying with due diligence obligations under mixed agreements. And Mr. Giannopoulos refers to the Paris Agreement. and at the same time for aiding or assisting its member states in a similar internationally wrongful act, which can also be an omission on the behalf of the member states to comply with that due diligence duty. Now, this is a rather complex question. But I think the gist of it is parallel responsibility.
Yes, I think this question has various aspects to it, but I think one of them clearly which stands out, to what extent one could foresee a situation here of parallel or a dual or multiple responsibility, which sort of dovetails a little bit with what Ilias was talking about earlier, about clarifying that there could be perfectly situations where the same conduct may be attributable to two different entities. And of course, we have a strain of cases such as Al-Jeda, such as Muhanovic and Mustafic. So we have already a number of jurisprudential developments in this respect, and the articles themselves do recognize this possibility that the same conduct may be attributable to multiple actors. Now, that of course is a separate question from a situation where it may very well be that the obligations engaged by states and an international, which are members of an international organization. So an international organization has an obligation, and member states would have an obligation with a similar content or even the same obligation. And so by their individual conduct, international organization will engage its own responsibility by failing to meet national contribution of reducing by 25% by X date. So they would individually also breach that particular obligation. So you could have perfectly two different kinds of situations. So we have to distinguish here whether we are talking about the one single internationally wrongful act, which may be, for example, a result of various actions and omissions as well, or whether we are talking about two separate internationally wrongful acts, one being committed by the international organization and another one being committed by the state. And now, of course, to complicate all of this, there is this entire discussion that we've had about the normative control and in terms of how conduct is or is not attributable to the international organization, even when de facto who is acting is the member state of the organization. So obviously this question of Nikolaos raises a whole different, we have to kind of compartmentalize it in different layers. I'm not sure whether I even addressed half of the situation, but I think in principle there is nothing that could prevent such a situation from arising. And in fact, throughout the elaboration of the articles, it is interesting that the earlier versions of the provision on responsibility for aid or assistance was not so blatantly excluding situations that aid or assistance or complicity, as it used to be called, could arise as a result of an omission. Everything, of course, would depend very much on the surrounding circumstances, but it is only thanks to the ICJ's 2007 judgment that a strain of academic thought has developed, and also states very happily took up at that interpretation that aid or assistance or complicity as a matter of general international law can only arise in situations of positive action and not omission. And omission is reserved strictly for obligations, which are obligations of conduct, which require the state to exert due diligence.
Thank you. I wonder whether Ilias wishes to remark to Nikolaos Giannopoulos' question.
No, I think that Vladyslav has covered me. I don't disagree with anything that Vladyslav said. I think he covers the question. I wouldn't like to add anything to that.
Okay, and now I'm giving the floor to Dr. Vulgaris, who wishes to ask a question or make a remark.
Thank you very much again. It's actually getting late and I have about 12 questions for Vladyslav, but I'll just stick to one. Vladyslav, do you believe that the opposability requirement poses in practice problems as to the application of the rule on aid assistance? Thank you.
So if we take the most blatant cases of complicity, of which you will find allegations out there, if you read, for example, cases surrounding major violations of human rights or international humanitarian law, let's say the ongoing crisis in Yemen, and the fact that many of the states of the European Union, and this is all knowledge which is corroborated, have sometimes very strict conditionalities on rendering some assistance to states such as Saudi Arabia, etc. So in these situations, opposability doesn't really pose so much the problem, to the extent that you could say the underlying obligations which would be breached with the assistance of those armaments are erga omnes obligations, or obligations which are very well enshrined under customary international law and therefore binding on all states. For example, just for the sake of example, Saudi Arabia and France, and so the opposability requirement as such falls through. But in many other circumstances, it may well be the problem, particularly because the earlier construction of the articles and how they were understood in the commentaries and how most states understood them was that there was the requirement that the wrongfulness, which is in paragraph B, should derive from the same source of obligation. Now, Special Rapporteur Crawford, when of course he got the job done in 2001, only in 2013 came back to this question in his individual writings and said, oh, no, this is not how it should be interpreted, but the reality that that's how it was picked up by the states and by many international organizations. And so he said, well, what matters is just wrongfulness. It doesn't really matter whether, for example, the aiding entity is covered by a specific treaty obligation, whereas the aided entity is covered by the same content obligation, but sourced under customary international law. So you see here how interesting it may be sometimes, and this is where, depending on how you interpret this, it may be more or less of a problem. But let me say one last thing. When this limitation was never envisaged in the earlier drafts of the provision, be that Article 25 as proposed by Argon 78 or 27 later, and this limitation came with Special Rapporteur Crawford, who even conducted a comparative study of various jurisdictions to see to what extent you may have a situation of akin to inducement, where you are not necessarily bound by the same obligation, but you induce by providing that assistance to the party, that other counterparty will be breaching its own obligations. And this is where his logic came directly from treaty law understanding of Articles 34 and 35 of the Vienna Convention on the Law of Treaties, which essentially provide that a treaty does not create any rights or obligations for third parties. This is the logic that he tried to transpose directly to the regime of responsibility. The question that I ask, is it necessarily the case that the regime of responsibility, be that in international law or even in domestic law, should follow strictly the contractual in domestic law or treaty thinking in international law? I think it's a question which is very important, particularly when we are introducing into the conundrum international organizations, member states, external counterparties, and particularly in an organization such as the EU, which always claims that it is acting in accordance with all of the obligations as undertaken by itself, but also by its member states. So, question mark, how does this play for the complicity regime?
Thank you very much. As I see that there are no further questions or requests for remarks, I would like to thank both Dr. Plakokefalos and Dr. Lanovoy for their presentations, and I cede the floor to Vasilios Pergandis for the grand finale.
I don't know whether it will be so grand. Thank you very much, and both presenters and Professor Antonopoulos for chairing this panel. Now, I will be very brief because I know that it has been a long day for all of us. I think that this discussion, today's conference, was a very nice opportunity to introduce the various aspects of the topic of EU responsibility in the international system. There are issues that pertain to the international rules concerning responsibility. We had a lot of discussions about whether we need the attribution of responsibility paradigm or not, whether normative control, in which of those provisions normative control should be included. And of course, there were also issues concerning shared responsibility. And you also have, by adding the European Union to that equation, also the problems concerning its constitutional principles and its functioning. Autonomy, logical cooperation, we heard about it. It has to do more with implementation of responsibility, but it is also a very crucial element. I wonder whether logical cooperation can even impact in the attribution discussion, because there is also there some issues. You also have other principles such as the subsidiarity principle. You have this situation of the executive federalism that is applicable in the European Union. So all these elements, I think they form a very complex, but also a very intriguing topic that we are aiming to present gradually to the audience and to those that will follow our work during this 1.5 years, because the first half year has passed. Now, if Professor Gavouneli doesn't want to say something as the president of the Hellenic Branch of the International Law Association, perfect.
Everything has been said.
Let me close by taking this opportunity to thank everyone who contributed to the realization of this academic event, especially the Kalliopi Koufa Foundation for the promotion of international law and human rights law, and Emeritus Professor Kalliopi Koufa for encouraging our scientific endeavors within the foundation and providing an academic environment that contributes to the efficient development of our academic activities, which we don't always find at the university. You can visit the webpage of the foundation in order to learn more about it and about its work. I would also like to thank the Hellenic Branch of the International Law Association, and particularly its president, Professor Maria Gavouneli, and the members of the governing board for collaborating with the foundation and the EURIS Jean Monnet Project and supporting this event all the way. I would like also to thank the Law Faculty of Aristotle University for supporting the event. Now, special thanks go to Christos Zois, Alikis Emergis, Stefanos Katsoulis, and Marilena Papadaki, scientific collaborators of the Jean Monnet Project and the Kalliopi Koufa Foundation, for respectively for providing valuable assistance regarding the preparation and organization of this event. And I would equally like to recognize the chairs of this conference for keeping the program almost on schedule and steering efficiently the debate. Last but not least, most importantly, I would like to thank all the panelists for presenting. Some of them are friends and we know each other many years. Some of them I met you for the first time and I was very interested in the ideas that you presented. So I want to thank you all for presenting your work today and for contributing to the smooth unfolding of such an interesting academic event. And also Dr. Parasivirta for delivering a highly interesting and engaging keynote that offered a panorama of the challenges raised by the EU responsibility in the international system, combining a scholarly approach with the experience of a practitioner that has lived and perhaps lived the EU and suffered from it, perhaps, from the inside. So thank you very much, all of you, and I hope to cross your paths also physically very soon as we start again traveling around the world. Thank you very much.
Thank you. Good night.
Bye.